Hello, my name is John McKenna and I'm the course coordinator of a law school master's subject which is concerned with the interpretation of statutes and instruments. This subject was first introduced into our master's course in 2021 because it seemed to me to be the single most important topic for practitioners wishing to study at master's level. For all of us in legal practice, no matter what our practice area is, we have to grapple with issues of statutory or contractual interpretation on an almost daily basis. For transactional lawyers, these issues arise as documents are sought to be drafted with a meaning which is clear and unambiguous. For others, these issues arise virtually every day as we seek to apply the provisions of a statute, contract, or will to the circumstances of a particular case. While many of these issues are readily resolved, difficulties commonly arise when events unfold in a way which was never contemplated at the time the statute or contract was drafted. Of course, as undergraduates, we were all introduced to the principles of interpretation which are used to resolve issues of this kind. And on their face, these principles seem fairly straightforward. In short, the courts have told us to construe the text by reference to its plain meaning, by reference to its context, and by reference to its purpose. In practice, however, the application of these principles is often very challenging, with even the courts reaching very different judicial answers to a particular issue as matters proceed up the appellate ladder. The purpose of this master's subject is to provide Australian legal practitioners with the intellectual toolkit they need to reliably analyse and resolve issues of this kind. It is taught intensively over 2 weekends using a small group seminar format. During the course of the 2 weekends, a range of eminent presenters, judges, barristers and solicitors will work through a sequence of about 25 separate topics relating to both statutory and contractual interpretation. The course is open both to master's students and to practitioners who do not wish to complete the assessment tasks but merely wish to take the course as part of their continuing legal education. For the master's students, the assessment exercises are designed to fit in with the demands of ordinary life. So after the first intensive weekend, there'll be a take-home statutory interpretation problem to solve. Then the rest of the assessment will be based around a 4,500-word paper on a topic of the student's own choice, which can be prepared over the course of the semester. Ideally, this paper would be of publishable quality so students can gain not just credit for the subject, but wider professional recognition through a published journal article. I should mention that all those involved in presenting this course are UQ alumni who do so on a voluntary basis, with the teaching fees being donated to the Law School Scholarship Fund for undergraduate students who are in financial need. The official details of this course, including the final enrolment date, are to be found on the University of Queensland website.